these are not occasions where you cut deals with the judiciary.
6 years after the Ayodhya Ram Mandir Babri Masjid verdict, an interview of former Chief Justice B.Y. Chandrachud has led to demands that a curative petition be filed in that case. Professor G. Mohan Gopal, former director of the NLS Bangalore, said that the remarks may give enough grounds to file a curative petition. But what is a curative petition? A curative petition is the final constitutional recourse available after an appeal and review petition has been dismissed by the Supreme Court. While the Constitution per se does not explicitly mention this kind of petition, the Supreme Court established this remedy in 2002 through a landmark judgment in Rupa Ashok Hurra versus Ashok Hurra. Now this, remember, is a mechanism to correct any glaring errors that could lead to a miscarriage of justice. The court drew from its powers under Articles 137, 129 and 142 of the Constitution, which allow it to do complete justice, and the bench has laid down extensive guidelines for how such a plea can be filed. Curative petitions are heard in chambers, not ordinarily in open court, but they can be if the judges agree. Typically, the three senior-most judges of the Supreme Court and the judges who pass the verdict examine these petitions and then take a call on whether it needs to be reheard. And it can only be done on very limited grounds. First, of course, is the violation of principles of natural justice. That means that the petitioner was not heard on some specific legal point. Then, discovery of new or important evidence that was not available during the original proceedings. A precedent error that is grave and fundamental, or allegations of bias or malafide against a judge who participated in the decision. But one must demonstrate that the earlier verdict was based on that fundamental error which led to a significant miscarriage of justice. Additionally, a certificate from a senior advocate is mandatory when such a petition is filed, confirming that it is not a frivolous plea. And over the years, curative petitions have been filed in high-profile cases such as the Nirbhaya case, the 1993 Mumbai bomb blast case, and the Bhopal gas tragedy compensation issue. In some instances, these petitions have been dismissed, while in some others, they have led to significant judicial reconsiderations. However, curative petitions are not a tool for re-arguing a case. In fact, in the Bhopal gas tragedy case, the Supreme Court restricted this kind of plea for when there is a gross miscarriage of justice, fraud or suppression of material facts. In essence, curative petitions serve as a safety net, ensuring that the Supreme Court's decision uphold the principles of justice and fairness.